Okay. So Erin, thanks for being here with us, and the room is yours.
Awesome. Thank you. And thank you for having me. I'm really excited to give this talk. So, as mentioned, my name is Erin Gursky. I'm the owner and CEO of copyrightlaws.com, and I'll explain a bit more about what copyrightlaws.com is in a few minutes. Also, apologies for the light behind me. This is the light coming in the window, and I think it's probably better to have that than this spotlight on my face. So, if you have trouble seeing me, just let me know and I'll see if I can adjust it. So, as Anna mentioned, I've been working in copyright for over a decade. I started off as a copyright officer at the Canadian Museum of History, and I made my way up to becoming the advisor of intellectual property at the Canadian Museum of History in Gatineau. I then moved on to copyright visual arts, or COVIDAV, which some of you might be familiar with. At the time, the position was known as the licensing coordinator, but now it is the executive director. So Marcia Lee is the current executive director, and she's doing a fantastic job. And from there, I went on to become the owner and CEO of copyrightlaws.com. So I've actually been working as a teaching assistant for this organization since 2019, but I only bought the company in July. So it's not been that long, um, but I am definitely enjoying it. So, what is copyrightlaws.com? I'll just quickly give you a rundown so you know kind of who I am and what I do. It was founded in 1998 by Leslie Ellen Harris, who is a lawyer, an American lawyer, copyright lawyer. She's also a consultant, a published author, a blogger, and an educator. She founded this website to provide copyright courses and education in plain English, independent and non-biased training, and also to just empower people to feel more confident when it comes to copyright issues, because as anything legal, as we're all aware, it can get quite complicated, especially if you're just reading the act. It can get a little confusing, and trying to keep track of all the different laws and updates and modernization, all that can get quite complicated. So this course, or well, these courses and this website was created to try and work through all of that complication and make it easier for everyone to understand. So we do offer a whole bunch of courses, from certificate in Canadian copyright law, which is obviously focused on copyright law in Canada, but we also do the copyright leadership certificate, the certificate in licensing digital content, the Essential Guide to Managing Copyright Issues in Publishing, which all of those are not country specific. So we have students from all over the world who take our courses. We also have a bunch of primers and e-tutorials, which are smaller and kind of more focused on specific copyright issues and challenges. And just quickly, our next courses are starting on October 2nd, but our course calendar for 2024 will be up on September 30th. So that's all I'm going to say about copyrightlaws.com. And then I will move on to what you're really interested in, which is information about copyright in Canada. So I'll just start with the basics. So what is copyright? It's literally the right to copy. So it provides artists with control over the use of their creations, as well as the ability to benefit monetarily or otherwise from their creations. So it was put in place to basically help people to protect what they create. Um, it's been in existence for hundreds of years, but the most recent iteration that we have, I think the latest large modernization of the Copyright Act was in 2012, but some of you may know that we recently had a further um, amendment, a pretty important amendment to it at the end of last year, which was to extend the duration of copyright from life plus 50 to life plus 70, which we will talk about in a minute. It actually also, other than the right to copy, it actually also protects the reputation of creators, which is their moral rights, and also the rights of performers. So it's pretty broad. It's part of the larger category of intellectual property. So it protects what's intangible or intellectual in nature. So it doesn't protect the physical copy of something. So in terms of visual art, it's not protecting the physical painting itself, meaning if somebody were to buy a painting you've created, they're not buying the copyright along with that. They're just buying the physical painting, and you would retain the copyright. And as part of this larger grouping of intellectual property, you also have patents, trademarks, industrial design, and confidential information and trade secrets. So copyright is just one piece of that. So copyright in visual arts in particular. Obviously here we have some examples of different types of art which are categorized as visual arts. Copyright in Canada and in all Berne countries, Berne Convention countries, which again we'll get to in a minute. I promise I'm going to explain everything. Copyright is automatic. So upon creation, you automatically have copyright protection, which is fantastic. And it is based on three categories: originality, fixation, and nationality. So for originality, there's no real definition in the act as to what original means, just that it can't be a copy of an existing work, essentially. So it's not a judgment on how creative it is, it's just it's a new work, essentially. In terms of fixation, in order to be protected, the work has to be in a fixed and tangible form. So, for example, not that this would apply to, well, you know what, for visual arts, okay? So if you were to create a temporary artwork that is part of an installation, a living installation, and then after your work is done, the artwork disappears, that wouldn't be protected by copyright unless there were photographs taken of it or video taken of it, and that would be protected by copyright. And a more or an easier example would be if you were to play an improvised song and it wasn't recorded, that improvised song is not protected by copyright. And then the final factor is nationality. So basically, in order for all of this to apply, you have to be either Canadian or a member of another treaty country. So the three main treaties are the Berne Convention, which we will talk about later, the Universal Copyright Convention, or the World Trade Organization, and then there can be kind of individual agreements made between countries to determine that their artists would automatically be given copyright upon the creation of their work. And really important, artistic work is generally not judged by artistic or aesthetic nature. So as I said before, and as you can see on the screen, there are all kinds of works that are considered visual arts, and they are all protected automatically upon creation. So this might seem intuitive, but I've had questions about this. It doesn't matter if somebody thinks your work is art or not. It's still protected as a visual art. And in case you might work on other different types of works, copyright also protects literary works, any kind of written documents. So letters would count as a copyrightable written document, dramatic works, musical scores, arrangements and adaptations, translations, government materials, performers' performances, sound recordings, all of that is in the act. So it's pretty broad. Oh, apologies. Okay, so in terms of ownership, in general, in Canada and in most Berne Convention countries, the author is the first owner of copyright. So author is not defined in the act, but essentially it is the person who creates the work or expresses the work in tangible form. There are some exceptions to this or complications. So for commissioned photographs or portraits, after November 7th, 2012, the photographer or the person who creates the portrait would be the first owner of copyright. But before that, it was actually the person who ordered the work. Um, if as long as there was valuable consideration, so money or services exchanged, and the work was made because of their order and not before. So it was a little bit more complicated with commissioned photographs and portraits beforehand, but now it's just simply whoever takes the photo or creates the portrait is the copyright holder, unless there's an agreement to the contrary. And this is obviously really important because before it was getting pretty complex to figure out who actually owned the copyright, if there was any kind of monetary value exchanged, any services exchanged, and therefore was it the photographer or the person who commissioned the work who owned it. So it's much simpler now, thankfully. Also, for freelance works, make sure you check any agreement that you sign, because those will usually lay out who owns the copyright in the work that's created. For collective works, you can have copyright in the full collected work. So that would be whoever put it together. So for a book, it would be the editor or the publishing company, more likely. But there would also be copyright in each individual part. And for a compilation, it's the person who created the compilation. So, and important actually for visual artists, because I did encounter a lot of questions about this when I was working at the museum, was in Canada generally, if somebody creates something as an employee, as part of their work for their employer, the employer automatically has copyright in it unless there's an agreement to the contrary. So that's something to keep in mind if you're creating works over the course of your work for your employer. Okay, so the duration of copyright. The basic understanding is that now it's life plus 70 in Canada. So what that means is it's for the life of the author, and then extends for 70 years beyond the end of that calendar year. So for example, if an author were to pass away in April, that it wouldn't enter the public domain in April 70 years later. You would go all the way to the end of December, and then you would start the 70-year term. This is basically just to make sure that it's much easier to determine when things are enter the public domain, because it's public domain day on January 1st. So we're not trying to figure out, okay, well, did the author pass away in April or October, or when does it become public domain? So really important to remember that it's at the end of that calendar year. And it used to be life plus 50 in Canada until the Canada-US-Mexico agreement of, I think it was put into force in 2020, but then the actual extension of copyright didn't occur until the end of December 2022. So this is fairly new, that now it is life plus 70. So that is, again, something just to keep in mind, especially if you want to use works that you think, might be in the public domain after 50 years as part of your artwork. That might not be the case. Also, the duration is determined by the life of the author. So even if the copyright is assigned to somebody else, the duration remains based on the life of the author. And that can be especially important when thinking of works where the copyright is owned by a company or a corporation. The duration still has to be based on the life of the author. There's a few complications in terms of exploited works, unexploited works, anonymous works, all that kind of stuff. But that is all in the Act. So I'm not going to get into too much detail there, just because it probably won't apply to most of you. Definitely important to note as well that there are specific rules for photographs that were created before the 7th of November 2012, which is when the Copyright Modernization Act came into effect. So that is all laid out as well on the website of the Intellectual Property Office. So if that applies to you, I would definitely check out their website. In terms of works of joint authorship, then the copyright will be based on the life of the last living author. So it can get, I remember my work at the museum, sometimes it was really complicated to figure out if something was yet in the public domain or not, depending on how much information we had on the authors or how many authors there were or when they passed away. So getting to know the duration can be really helpful, especially if you want to use copyright or materials that are still protected under copyright in your works. And something really interesting is that for Crown copyright, in terms of using anything that was created by the government, Crown copyright can actually be perpetual, which is one of the reasons why a lot of people want to get rid of Crown copyright, in that the copyright term actually starts once it's published, and so made available to the public. And so if it's never published, that duration never starts. So it can be protected forever. So just going back to that Canada, US, Mexico agreement, that was something that was negotiated during Donald Trump's presidency. And so basically we agreed as part of this agreement to extend our copyright duration term to life plus 70, which is actually in line with most countries across the world. Funnily enough, Mexico actually has a life plus 100 duration, so they didn't have to extend anything, obviously. But really important to note as well is that anything that was already in the public domain, so copyright had already expired at the life plus 50 mark before the 30th of December 2022, it remains in the public domain. So we didn't pull anything back from the public domain. And also, if copyright was set to expire at the end of 2022 because it's the 30th of December and not the 31st, then that does gain an extra 20 years. I know it's complicated. Important for visual artists is the exhibition rights. So this was something, interestingly enough, when I worked at the Canadian Museum of History, this was something that the Copyright Office was trying to get more project managers and curators to be aware of, because it was something that wasn't always followed. So I remember learning about this for the first time and then getting all excited because I had something new to sink my teeth into. So the exhibition right is essentially that a copyright holder has the right to present at a public exhibition for any purpose other than sale or hire an artistic work created after June 7th, 1988, other than a map, a chart, or a plan. So specifically not for sale or hire. So that would cover galleries who are hanging artwork specifically for it to be sold. They wouldn't have to pay an exhibition right fee, but for basically anywhere else that is a public exhibition, you are entitled to claim your exhibition right, which usually comes with a fee. So whether it's a public exhibition or not depends on a lot of things, and it's basically subjective. It's kind of a case by case basis, but it looks at things like physical location of work, the size of the audience, the purpose of the exhibition. So generally, if somebody put up a painting in their living room, that probably wouldn't count as an exhibition. I mean, unless you're Bridgerton style, having, a large public party in your ballroom and you have a piece of artwork very prominently on display, then that might be different. But if you're looking for what kinds of fees you can ask for your exhibition right, CARFAC has a full fee schedule, as you probably already know, and one of the items they cover is the exhibition rights. So they give a really detailed breakdown of what kind of fees should be given depending on the size of the institution, the size of the exhibition, how many artists are being displayed, all kinds of things. So definitely check out Carfax fee schedule if you have not. I find often users are aware of the fee schedule, but not always artists. So that is something to really familiarize yourself with, especially if you're licensing use of your works. That can be really helpful to have an idea in mind of what would be kind of an acceptable fee to request. So, in terms of reproduction rights, basically the author has the exclusive right to reproduce a work or any substantial part of the work in any material form. So it's not just photocopying something or taking a picture of something, it's much broader than that. So in the act, substantial part is not defined, and that's intentional because it really depends on the type of work. So, for example, if you took a tiny clip from a film, that might not be considered substantial, say a 5-second clip. But if you were to use a photograph, any amount of that photograph is probably considered a substantial part just based on the type of work. The author also has the exclusive right of public performance, of publication, of adaptation, translation, and telecommunication, which, as of the 2012 Modernization Act, that includes putting something online, making it available online. So anyone that tells you that, social media doesn't count, it does. It's a bit of a murky area in terms of, whether people share something or embed something or all the different fun things you can do with the internet. But just know that social media is supposed to respect copyright as well. It's not an exception. So you are well within your rights if you ask somebody to ask you permission before they post something on social media and to even request a fee for it. We at the museum paid fees all the time for putting something on our social media profiles. And again, the Carfax fee schedule has a good laydown of what kinds of fees should be expected for use on social media. So this is more related to users, but it might be something that you encounter when somebody is looking to use one of your works in some kind of project, and that is fair dealing in Canada. So fair dealing is probably the largest exception in the Copyright Act, the largest limitation on copyright. And what's really interesting about it is it's completely subjective. So they do give these 6 purposes that they count as fair dealing, possibly, to give some kind of guidance to it. And then they give the 6 criteria, which are the kind of it's kind of like a checklist users should go through if they're looking to use something that is protected by copyright under fair dealing. So because it's so subjective, fair dealing can only be determined 100% through a court case. So it can get a little hairy depending on how somebody is looking to use something and for what purpose. It's often misunderstood. I deal with fair dealing questions all the time in my work as a copyright educator. It's intentionally ambiguous. It's not formulaic, so you can't just, go through a list and say, okay, because I said yes to all these things, it's automatically fair dealing. It's something available to everyone, so it doesn't have to be just non-commercial. It's applicable to any kind of work, and it's all about applied judgment. So basically, it's a case-by-case basis and often involves risk assessment on the part of users. So just because they've decided something is fair dealing, the copyright holder can still decide that they don't feel it is fair dealing, and so they can challenge that. So it's always there's always at least a little bit of risk when somebody decides to do this or to use this exception in order to use something without permission. Um, so in terms of the criteria, they look at the purpose that you're using it for. So those are the 6 purposes over there. Well, I guess there's technically 8. um, but so it should fall under one of those purposes. Um, it looks at how much of the copyright protected work they have used, if there was a possibility for an alternative that was not protected, um, and the effect on the copyright holder. Say somebody used something. Oh, actually, there was a really interesting case in the States recently, where an Andy Warhol piece of Prince was used on the cover of, I think it was Vogue, but I could be wrong. It was a Condé Nast publication, and they used one of his silk screens of Prince, but his silk screen was based on a photograph by a fairly famous photographer. And what they found, so Andy Warhol's estate claimed fair use in the States, which is kind of their equivalent of fair dealing, because it was transformative. So he wasn't using the actual photograph, he had made a work based on the photograph. But the courts actually ended up determining it was not fair use, largely because the magazine could have paid the photographer for her photo instead of paying the Andy Warhol estate a large amount of money to use his work. Or alternately, the Andy Warhol estate could have gotten a license from the photographer to have their or Andy Warhol's work depicted on the cover of Vogue. So because it had such a large effect on the income of the original photographer, it was determined not to be fair use. So that is something to keep in mind because it is definitely very subjective. And often people will just kind of go around claiming fair dealing or fair use willy nilly when it actually doesn't apply. And in Canada, some of you might be aware of the ongoing challenges with the use of copyright protected work in educational institutions. So when the Copyright Modernization Act happened in 2012 and they created this exception for education, basically all educational institutions, or most of them, stopped paying licenses for things and said everything was being used for educational use. But often that includes even when they're using works in, say, course packs that they then sell for $90, which a lot of authors argue is a bit of a loophole and doesn't actually follow the understood definition of education being something that is provided for free and is meant for educational purposes only. And yeah, so fair dealing is definitely something that is constantly being challenged, and we'll probably see some updates to this in the upcoming years. So something to keep an eye on, especially if you find some works of yours being used by somebody under the defense of fair dealing. So something you definitely want to be on top of and have a full understanding of. So moral rights. This is kind of separate from the economic rights of copyright. And basically, they are there to protect personality and reputation. So they can't be, in Canada, they can't be transferred or assigned except after the author passes away. They can be passed on to their heirs, as moral rights last for the duration of copyright. They can be waived, or you can agree not to exercise your moral rights in an agreement. And they basically cover three areas. So attribution or paternity, integrity, and association. So the first one is kind of obvious, attribution of paternity. Basically, you have a right to have your name associated with any work that you produce, um, within reason. So one of the examples I see often is if a musical composition is being played during a film, they can't necessarily put the name of the composer right there on the screen while it's being played, but they will put an attribution to the composer at the end of the film. In terms of integrity, this is looking at um, the fact that nobody can distort, mutilate, or otherwise change your work, as basically in a way that would damage your honor or your reputation. And in terms of damaging honor or reputation, that is subjective. So you can decide if it's a damage to your honor or reputation. And association, I think, is a really interesting one, which is basically that you have the right to decide whether you wish to be associated with a product, a service, a cause, or an institution or not. So, for example, if you were really against smoking, you could say it's a moral rights infringement if somebody were to use one of your works as an advertisement or as part of an advertisement for tobacco. Not that we see a lot of that now, but it was definitely something that came up a lot in the past. But same as, say, you, um, if you don't drink and you prefer not to be associated with the drinking of alcohol, obviously, if a company were to use your work on a beer case, that could be a moral rights infringement. So that's kind of an additional set of rights that you have available to you. And interestingly, depending on the country, moral rights are also treated quite differently. So, for example, in the United States, moral rights are only applicable to certain visual arts, and only last for the life of the author, and then they expire. Whereas in France, which I believe is probably the country with the strongest moral rights in the world, um, their moral rights last forever. They are perpetual. So, for example, uh, say Monet, who obviously has been dead for quite a long time, for his estate, they can still claim moral rights on his work, even though he has been gone for so long. So that is also something to keep in mind, especially when we talk about national treatment in a few minutes. I hope I'm not going too fast. There's quite a bit to cover, and I want to make sure to leave lots of time for questions at the end. This one is kind of copyright adjacent, but something important to mention is the artist resale right. So basically, it would allow visual artists to receive 5% when their work is resold. So this is a right that exists in, well, as Carfax says, at least 94 other countries, that we do not have yet in Canada. So it's something that a lot of organizations are working to get included in our copyright legislation. It's a great tool because it allows artists and their estates to benefit financially from works on the secondary market, so works beyond the first sale. And something that I think is particularly important and would be amazing if we actually put this in place is that it can especially help Indigenous artists, because often their work, especially well, currently still, but especially a few decades ago, there were some artists' works may have been sold for very little money and now are considered these wonderful works of arts that are indicative of a certain culture or a certain band or a certain area of this landmass. And they are now worth hundreds of thousands of dollars, but those artists or their estates are seeing no further income from the sale of that work, even though they might have sold it for $50 and now it's worth 500,000. So I think this is an important change, and it's one that is still being debated in Canadian copyright law. So definitely something to keep an eye on. So now I will just talk quickly about the Berne Convention. So this is when I was talking previously about national treatment. Hang on, I'm going to see if I can turn this on. It's getting dark in here. It was, yeah, when I was talking about national treatment, it's basically the fact that if you are one of the treaty countries in the Berne Convention, which the full name is the Berne Convention for the Protection of Literary and Artistic Works, you really benefit from protection across much of the globe. So basically, this is managed by the WIPO, or the World Intellectual Property Organization. And there are close to 200 countries that are signatories to this, including Canada and the States and the UK and most European countries. So what this sets out is a minimum standard of protection. So at the very minimum, countries that are signed on to this need to protect their works for life plus 50. It also establishes national treatment. So basically, if you create a work in Canada and it is used in another treaty country, like the United States, the law of the United States will also protect your work, even though you're not an American citizen. It also talks about what rights need to be guaranteed, as well as what the minimum requirements are for moral rights. So it's a huge, huge treaty, and it kind of takes the place of international copyright law. There's no such thing as international copyright law, only national. So this kind of gives a bit of standardization across the countries that have signed on. So as I said, it's over 200 countries, which is amazing. I think the states signed on pretty late, but at least they're there now. Okay, I'm just going to turn the light on because it's getting real dark in here. Okay. Okay. So last but certainly not least, just a quick spiel on negotiations. So often what I found when I was working for Copyright Visual Arts is that artists would feel quite intimidated when going into negotiations in terms of licensing their work, especially if they were negotiating with a large institution. So like when I worked at the Museum of History, I would often find that artists were a little nervous in the negotiation process because they just figured that the museum was going to request all the rights ever, kind of like publishers do. They say, you know, we want all the rights perpetually, forever, until the end of time, which in most cases is overkill, but often artists would feel that they just didn't have the knowledge going into negotiations. They knew they wanted to get paid, but they didn't know much about reading contracts, or if they could even negotiate clauses in contracts when handed something by a large institution or corporation. So I always found when I was speaking to artists who were members of Copyright Visual Arts that it was really important to remind them to know their rights. So get familiar with the Copyright Act as much as you can. Even if you can make a little cheat sheet for yourself, CARFAC has some great resources in terms of, making it clear what rights artists have in Canada and abroad. Know ahead of time what you're willing to license. So if you have your line in the sand where, you know what, I'm comfortable with this being used in an exhibition, but I'm just really not comfortable with it being used in any kind of marketing campaign, make that clear and stick to it. I mean, the licensee cannot force you to sign over any rights that you are not comfortable signing over. So just make this clear ahead of time, and also keep an ongoing list of what licensees are asking you for, to see if you can revisit this list in the future and see if, say you're often asked for the right to reproduce your work on social media and you've always said no, well, see if you can find a way. If this is looking like something a lot of people want to license, then you can take some time to figure out if this is really something that you're strongly against, or if you would be okay with it depending on the types of terms and conditions that are involved. Also, always consider your moral rights. This is a huge one. I mean, there was a big case in Canada when it was, I think it was at the Eaton Center. There was an artwork that was like a flock of geese that was hanging from the ceiling, and it was used, I believe, in an advertising campaign, and the artist objected based on his moral rights that he did not agree to being associated with this product, and he won that case, and they had to stop using his artwork in that respect. So moral rights are important, and they will be respected if you insist upon having them respected. um, take your time when it comes to negotiations. Again, it can be quite intimidating, especially if you're dealing with lawyers, um, to go into these negotiations, but just take your time, read everything, read all the clauses, ask questions if anything's confusing. If anything, the licensee wants to know that they have acquired all the rights they are looking to acquire, and they want to make sure you're comfortable with that so that they're not going to encounter any issues in the future. So they would rather you ask questions and ask for clarification than not, because that can lead to issues for them in the future. And also, in terms of if somebody is acquiring your work for a collection as part of the negotiations for that, something we were moving away from at the Canadian Museum of History, and I think a lot of institutions are moving away from now, is the idea of assigning your rights when an institution takes your work on as part of a collection. Um, at the Museum of History, what we often talked about was how that really complicated things, because another right in Canada is the reversionary right, which basically means if copyright is assigned 25 years after the death of the author, the rights revert back to their estate unless the rights are further assigned in their will, which usually they aren't, because usually they've forgotten that they assigned rights in anything to any institution. So at the museum, this got complicated because we had works where we had the rights assigned, but now the author had been dead for 30 years, and we realized we no longer owned the rights, even though we had this document that says the rights were assigned to us. So um, when looking to negotiate whether your work will become part of a collection, I would suggest pushing back if they ask you to assign your rights, and look to see if you can produce a license instead. It's just easier for everyone involved. Um, I also really should have said this at the beginning of the presentation, but I hope it's assumed, since I did not talk about a law degree, that any of the information I gave in this presentation obviously is not legal advice. This is just based on my experience and based on my knowledge, and I hope that it's useful. But obviously, if you're really in a bind and worried about something, always seek out the advice of a lawyer if needed. And finally, so I thought I would just end with some resources that you can check out for further information. I know I just threw a lot of information at you in terms of copyright, and I will not be offended if you didn't take everything down and memorize everything I said. So for further information, I've mentioned them a few times, but definitely CARFAC or RAV in Quebec. They have great resources for artists, a lot of information on copyright and knowing your rights. And they also have that fee schedule I mentioned a few times. So that can be a really great starting place. Often institutions will go to it in order to determine how much an artist should be paid for a certain use of their work, but just in case they don't, it can be really helpful to familiarize yourself with the fee schedule and what their suggestions are in terms of the kind of um, compensation that you can ask for the use of your work. They also do a lot of trying to think of the proper word here, but basically they fight for artists' rights. So they're a great organization. I worked with them very closely when I was working for Copyright Visual Arts, and they do a lot of great work. So definitely check them out. And then related to that, Copyright Visual Arts, or COVADAV, is another organization. So they are kind of the licensing arm of CARFAC and RAV. So you can become a member of Copyright Visual Arts and they will do licensing requests for you. So that, at least when I was there, the artists that I worked with mentioned that it was a great service because it just took something off their plate that they didn't fully understand or that they weren't fully comfortable with. So it can be really helpful to have somebody in your corner to help with any licensing challenges, especially people who know their stuff. So, and they can often get you a better licensing deal than maybe you would have gotten had you felt overwhelmed or kind of out of your comfort zone when negotiating a license. Obviously, I have to plug copyrightlaws.com. We have so many resources on the website, blogs, tips and tricks, courses, e-tutorials, all kinds of stuff. So if you do have a moment, please check us out. It's Leslie's life's work. She did an amazing job building this company. I bought it because she retired this summer, well deserved. So I'm very proud to now be heading up this company. And I really do think that we do a great job at providing information in a way that is digestible and not intimidating. So hopefully you found the same about this presentation. I tried not to talk too fast or cover too much. So, but there is so much further information on the website. And then finally, just a generic call out to the Canadian Intellectual Property Office. They obviously have a copy of the Act as well, but they have a lot of resources to help make copyright accessible, as well as people that are there to answer questions if you have any, and a lot of information on what your rights are and how you can make sure that they're respected by users. So definitely a great resource. They have videos as well, and they work closely with the American Copyright Office as well. So if you do any sort of cross-border work, that the I think it's I can never remember their acronym, but the American Copyright Office is also a fantastic resource if you're doing any work over in the States. So that's all I had to say. I'm surprised I got through that as fast as I did. I thought it was going to take a lot longer. But I covered kind of all the basics. As I said, I definitely threw a lot of information at you. So again, if you missed anything, you can check out our website or all the resources I provided. Actually, I'll just go back. I'll leave that on the screen so people can write it down. But yeah, if anyone has any questions or comments, I'm open to anything.
We have a question here in the room.
Hi, I'm just wondering if someone makes some work that's digital in nature and it gets on social media, and since it's digital in nature, it's easy for someone to actually create the image in, like in 2D. I'm just wondering, how can one prove that it was your image before the other person takes it, type of thing?
Yeah, that's a great question. So I dealt with this quite a bit at Copyright Visual Arts, and what we always suggested was saving a copy to something, a hard drive, an external hard drive, a screenshot of it, something that basically has a timestamp on it, that you can then keep in a safe place so that if you run into any kind of infringement issues, that you have this visual proof that no, I created this on this date. Here's the date associated with whatever it is. Like I said, even a screenshot is fine, or a photograph of it. But as long as it has the date associated, that can be a pretty strong defense if somebody were to infringe your work.
Right, it's not like someone can reclock their computer and, you know, say that, no, I've created the same, you actually copied my work because I
Yes.
had work.
Exactly. And there is precedent for this being used as a defense when somebody did infringe someone's work. So.
Okay, so a digital photograph that's time-stamped in some fashion is an acceptable means of representation of the time in which it was created.
Yeah, based on my experience, again, it's not legal advice, but I've seen it used as a successful defense.
And can someone take a photograph of your work and print it as a photograph and then deem it as copyright for them because it's a photograph?
No. So in Canada, this was something that was debated a lot because, especially for museums, for example, they often photograph their collections. They usually photograph their collections. And so there was a lot of talk about how there's a new photograph or a new copyright, excuse me, in the photograph of the work. But basically, understood best practice. Again, this is an interpretation of the act because it is often left intentionally vague, but understood best practice is that if the photograph doesn't lend anything new, so for example, where there would be a new copyright would be if you were filming a television series and there was a work of art in the background of that scene, there would still be a new copyright in that the filming of that television series. And there would also be underlying copyright in the work itself. Whereas if somebody were to just go to a museum and take a photo of the work, that is a reproduction, not a new work.
Thank you for your questions.
Yes, thank you.
I have a novel that I wrote several years ago, and it's registered, but it's not registered here in Canada. I believe next year it's gonna be published. So do I have to register the novel here in Canada, even though that it's registered outside?
No, so actually, one of the agreements when a country joins the Berne Convention that I spoke about is that registration cannot be mandatory for copyright protection to exist. So copyright protection is automatic upon creation of the work, which includes the publishing of your novel. So you can register it as an added protection in terms of just being able to prove that it is your work, but it is not mandatory in order to have copyright protection.
Thank you. Thank you. There's any more questions here?
If there's a work that's been written down, like in my sketch pad, and it's dated, but it's only written down, is that technically copyrighted in the sketch pad?
Yep. Yep. As long as it's fixed in a tangible form, it is automatically copyrighted.
Wow.
Yeah. So even something a lot of people don't often realize is that if you write a letter to a friend, regardless of where that letter ends up, you still own the copyright in it, even though it could be 2 lines. It's still copyright protected.
And there was a point where people were making, like artists like Basquiat were making postcards, or there's also some artists from, I think the 60s that were doing postcard work. I think it was Ellsworth Kelly, and he was sending them out. That's copywritten as well to him, right?
Yes.
Or does once he sends it through the mail, it's then, I guess the postcard's owned by the person that it was mailed to, but the image is technically copywritten to the artist.
Exactly. So that's the difference between intangible and tangible property. So the physical object versus the intellectual property inherent in it. So that's where you get a lot of the complications of people digitizing novels without permission and saying, well, I own the novel, so I can do whatever I want with it. Well, no, you own the physical novel, but you don't own the copyright in the novel. So all of those reproduction rights still belong with the author, or most likely in many cases, the publisher.
How many cases are there at any one time open with regards to copyright? Like, I'm wondering, now that we're in such a visually dense society where, you know, images are taken all the time of like original work, I'm just wondering, like, how many cases are open? Like, I knew of the one at the Eaton Center where they put the ribbon around the geese as an advertisement.
Yeah.
And you always hear about the Warhol ones, but
Yes.
are there a lot of other cases? And how expensive does it get to, you know, like you mentioned that, you know, only a court can determine it. How expensive can it get to try to protect yourself in one of these events?
Yeah, so there are, I mean, I know that in the States, for example, there are thousands of cases open right now, especially since the states created a small claims court specifically for copyright infringement. There is now thousands of open cases. And in terms of how how expensive it can get to defend this, that is definitely a challenge when it comes to defending your work. So in the States, as I said, they have this small claims court specifically for copyright issues, and so it minimizes the amount of money that can be involved and the amount that it costs in order to defend yourself against infringement. In Canada, you can it's a civil case, so it's less expensive than, say, a criminal case, unless depending on the use of the work and the scale of the use, it can become criminal. But it can get very expensive, and we often saw that, especially again with Indigenous artists who were trying to assert their rights in their copyright. And we had cases where fashion designers were using their work on dresses without licensing it, and then, you know, depending on the community they came from, how much money did they have to spend on these cases. So something I would suggest is definitely, if you're encountering this, to reach out to CARFAC and Copyright Visual Arts, because they have resources to help artists who are struggling to deal with infringements. And whether this is pro bono work by lawyers or just information in order to avoid an expensive court case and still have your copyright respected. I do see a lot of the time in a lot of infringement cases, it often just takes talking to the person who has infringed your work. Because if you're talking about, say, a blogger or somebody who uses your work on social media, that could be a simple, hey, you need to license this or you need to take it down kind of thing. And in a lot of cases, it'll be a really quick solution. But you're right, it can get very expensive. And I would definitely suggest checking out CARFAC and Copyright Visual Arts for resources on that.
Is there a boilerplate template of some sort in that event, the one you just mentioned, where a blogger might use an image or something, for them to license it? Like, I mean, I can't imagine how much the fee could be to license you know, an image because some blogger happens to be mentioning it in their blog that they went to, you know, they went to an art gallery, they saw your work, they take a picture of it, and all of a sudden, uh, you know, the blogger gets famous, and before you know it, your image is being shown extensively, and then, you know, other people are latching on, like tagging that to link to others. So is that where they would require a licensing agreement of some sort?
Yeah, so often what I'll see is artists will provide just sort of written permission for somebody to use. It doesn't have to be a license, say it's an email, for this blogger to use their work or to reproduce their work on their blog with attribution to the artist. And then it'll state that, you know, for any further uses, please contact me. And then that's where, yeah, the license would kick in. So, even if you can get anything in writing, like I said, like an email, that counts as a copyright agreement. So even if that is just to say you have the right to do this, but if it goes further than use on your blog, that requires further licensing. That is still asserting your rights.
So if I go to a gallery and I have to see an image that I like and I want to blog about it, and I want to put the image, it's my obligation to get in contact with the artist to say that I would like to use this image in the blog.
So that basically comes down to what I talked about in terms of fair dealing. So it's essentially a risk assessment that you have to make. So looking at those factors and the purpose of your use, whether you feel it falls under fair dealing, in which case you wouldn't need to ask permission, but understanding that fair dealing is subjective and decided on a case by case basis. So what you might consider fair dealing, the artist might not. So yeah, unfortunately it comes down to a risk assessment. I mean, in most cases, artists may not have a problem with you blogging about their work and including a photograph, especially if you're bringing attention to their work. But there are cases, I mean, I've dealt with bloggers who have put photographs on their blogs where the photographer has, you know, come knocking asking for $10,000 for a license to use their photograph on their blog. So it really does depend on the case, unfortunately.
And just one more question with regards to something like graffiti, since it's an artistic image, or at least the artist that created it believes it to be an artistic image, what happens in that case with regards to copyright? Like, I mean, what about if it gets destroyed? What about if it gets, you know, another image gets put on top of it or something like that? Has anything ever happened with graffiti in regards to copyright?
With what, sorry, in regards to copyright?
With graffiti.
Oh, yeah, that is a very specific case and often widely debated. So the general understanding is that copyright can exist in graffiti, but more often than not, it boils down to the artist producing the graffiti usually doesn't enforce their copyright. Often or sometimes, graffiti artists are producing their graffiti on property that is not theirs. So they're kind of complicating their rights in that respect. But if it's, say, like a mural, there's usually more understanding of the protection of that. Whereas when it comes to, say, tags or less, I guess, legal, for lack of a better term, graffiti work, generally it's more that the artist who created it isn't going to enforce their copyright.
Great, thanks for all your questions. We have another question in the chat box from Sonia. She asked, does the artist reserve right apply in the US?
That is a really good question. So I know the UK has it, and I know a lot of European countries have it. So I'm going to look that up right now because I feel like this is something I should know. It's kind of copyright adjacent, like I said. So it's not something that comes up in my work very often. Yeah. So United States, mandated a 5% royalty on the resale price of any work of, well, they say fine art. So I would suggest going to the US Copyright Office website for further information on that, because they will probably more clearly define what constitutes fine art, and so therefore what is applicable in terms of the resale right, but they do have it. So I learned something new tonight. Thank you for that question.
Amazing. Do we have any more questions for Erin? Folks online or here in the room? No, apparently not. So Erin, thank you so much for your time, for all the information. This is really useful, I think, for all of us. We have the recording. We will share that with you. The next professional development workshop is about arts administration and project management for artists. It's on October 11th. So all the registration links are on our website already. That one is going to be in person. We hope to see you here. And yeah, stay tuned. We have networking events for artists, gallery shows happening. So yeah, thanks all of you for joining us tonight. Thank you very so much for all your knowledge, and
Well, thank you for having me.
have a great evening, everyone.
Yes, you too.
Bye.